Hi, I'm Steve Link with Cornerstone Advisors Asset Management in Bethlehem, Pennsylvania. And joining me today is my colleague, Angela Ost, who manages the plan giving administration of many of our nonprofit clients. We are pleased to be with you again today on behalf of Wayne County Community Foundation to discuss planning for your future.
So Steve, today's topic in this series is gifts to heirs and charity.
I should note before we get underway, Angela, of one disclaimer: we are not estate attorneys, CPAs, or licensed financial advisors, and we do strongly encourage you to speak with your professional advisors planning to make any decisions with significant tax implications.
Absolutely. Thank you for sharing that, Steve. So to get started here, the first question I have for you is, how do most people leave gifts to loved ones and to charities?
This is going to sound like a lawyerly answer, and it's not. It depends. So roughly 80% of gifts to charities come from bequests, people simply naming the charity in their will or naming them as a beneficiary on a life insurance policy or retirement plan assets, that kind of thing. A big piece of it is whether people are leaving a specific dollar amount or whether they're leaving a percentage. And today I'd like to spend a little time talking about some of the differences in the implications, pros and cons of a specific bequest versus a percentage bequest. So digging down, a specific bequest allows you to quantify what you want to do for someone, but doesn't necessarily take into account what is happening with your estate, whether it's growing dramatically from the time you set up your will or designation on your beneficiary form, or shrinking. And certainly, I think we've all seen, the stock market has risen and fallen pretty dramatically in a very short period of time. So when I'm speaking with donors, I frequently encourage them to think in terms of percentage terms across the board, percentage terms for their living heirs that they wish to benefit, and percentage terms for any charities they wish to benefit. So everything stays relatively in ratio or in par with one another. This is particularly helpful if there's a sudden drop in the stock market or you haven't had time to go back and revise your estate plans and your estate has grown. You never want to unintentionally disenfranchise or harm your living heirs because your estate has grown and you only left them a specific dollar amount, which seemed very generous at the time and now seems small in comparison to your total estate. Percentages also help in terms of when it comes to retirement plan assets, and we'll touch base on that in a couple of minutes.
Perfect. Very helpful. Thank you, Steve. So different assets can transfer in different ways. Can you outline some of those ways?
Sure. So if you have a joint bank account, those assets will pass automatically through law to whoever the joint person is on that account. If you leave a beneficiary designation for a retirement plan or life insurance, that guides how those assets are distributed. Your will not go back and change any of that because those are different types of legal arrangements for how those assets pass. So if you make the decision that you name, say, a child or a grandchild to be joint on a certificate of deposit or some other account, and that becomes a outsized portion of your estate, even if you say in your estate percentage terms for all of my living heirs, those assets that are in that joint account will pass to the designated person regardless of your wish in your estate plans, perhaps to divide everything equally. So they'll get an equal share, perhaps, of what you've included in your will, plus they will get the joint account assets that are there at your passing. So this is part of why, while it makes sense to make sure that there are individuals who have access to immediate cash to help with things related to your estate, it is best to direct most of your asset allocations through your will if you want things to happen equally. And in the case of retirement plan assets, which are tax disadvantaged dollars, and I will go into this in a moment, it's good to keep everything in percentage terms because that way things remain relatively equal across the board as you wish and whatever the percentages are that you designate. Property transfers by title. So a house or a car will have a legal beneficiary on that. So if you own the house jointly or tenants in common, it will pass by that title. If you own a car and you have another person's name jointly titled on that car, it will pass to that person, just like the bank account that's a joint bank account will pass to the other living heir.
Okay, so I think my key takeaway from that then, Steve, is the fact that you really want to make sure that the donor's advisor team is on board and understands all the assets that are in place so that everything is transferred in the most efficient manner. Is that accurate to say?
That is completely accurate. And in one of our other segments, which you may or may not have already seen, we do talk about the importance of making sure your professional advisors see the totality of your assets. It's really good to build a complete listing of all of your assets. So when you sit down with your professional advisors, they know the breadth and the complexity of the assets that you hold.
Perfect. So along those same lines, you talk a lot about unintended consequences. So you always talk about cautionary tales that we should all be aware of. What would you caution viewers about?
So there are a lot, and I already mentioned one, this cautionary tale of potentially leaving a specific bequest to one individual or one organization and percentages to the others. That can be a totally unintentional situation. Another is not updating your beneficiary designations. So I have a case of a sibling that passed away very young at 65 and did not leave a will and had not done the steps to make sure that assets flowed properly, which created a mess for his widow. And I mentioned this in some other segments as well. It's really important that you are updating your beneficiary designations for spouses that have passed away, children or grandchildren that have passed away, ex-spouses. The last thing you want to have happen potentially is to leave on a beneficiary designation form a former spouse, basically disenfranchising your current spouse, or likewise for your other heirs where there's been a separation in the family or a death. Another is mismatching assets with heirs. And so in this case, I would like to drill down a little bit in tax disadvantaged dollars. Those would be things that have not been taxed already and will incur a tax for your beneficiaries, your heirs. Tax deferred retirement plans, for the most part, will be subject to both an income tax and potentially an estate tax, depending on the size of your estate. And those dollars may leave them with 30 to 40% of the original value that's there at your death. Whereas if you left those assets, those tax deferred assets, to charity, they would get 100 cents on the dollar, and you could leave other assets that are more protected in terms of appreciation in a house or appreciation in your stock portfolio that would pass directly to your heirs without taxation. So these are a couple of the areas that you should be talking with your professional advisors about: which assets make the most sense to give to individuals and which assets make the most sense to give to charity, to the extent you have charitable intentions.
Perfect. Thank you, Steve. And thank you so much for all of your knowledge and expertise on this topic. We really hope that this gives all of the viewers from Wayne County some food for thought. Thank you all for joining us with this segment, and hopefully you all can join for another topic that we will be sending out shortly as well. Thank you so much and have a great day.
Thank you.